custodial orders of 14 days. Your Honor, the respondent sought time so that Your Honor, he can seek legal representation. Your Honor, the matter is being mentioned today, that is on the 29th of September 2024. However, Your Honor, Court has not yet issued any orders in that file.
Your Honor, maybe in the interest of time, we have already addressed the issue.
Your Honor, Court has not yet issued any orders. I believe the file is before you. Your Honor, the file is related to this matter. And Your Honor, it's the same facts, the same, albeit a few alterations, the same facts, but Your Honor, for this application, that is E3809 of 2025, we have attached inventories.
E38.
Yes, Your Honor, this is in relation to E3805 of 2025. Your Honor, it comes from the same set of acts. Your Honor, the investigations in this matter as a step forward, Your Honor, after the arrest of the 5 respondents, where Your Honor, we have attached inventories.
Sorry. So these are the 5.
Yes.
Is there direction from the 5 that we can't see?
Your Honor can guide the court in that regard.
No, I'm asking the system.
No, Your Honor, from the information as I was entering court, I wasn't given any information on orders, if any have been given in court file.
Your Honor, I'd really wish to assist the court in regards to that matter. I was personally in court file. We agreed that the file be transferred here to be dealt with together with the other file. So there are no orders or any directions in regards to other than the one for transfer for that file to this court.
Yes, if Your Honor, if the file has been transferred here, therefore the respondent either between each has also to be.
So you want them to be consolidated? Or?
Yes, Your Honor.
So you're already here. You can see 6 people. Right on.
Yes, Your Honor.
Umeelewa vizuri?
Yes, sir.
Yes, Your Honor. If I may proceed with the application. Your Honor,
Maybe Honor, for completeness of record, Anyoka for the, now, I don't know, there's 6. Together with my colleague, Mr. Ekusi Lore. I'll be together with Ekusi Lore. Thank you.
Right. There's a lot of space and they're limited to standing. Now we can interact. Tafadhali wenye wamekaa, songa kidogo ndio.
Your Honor, in this application, we are seeking 14 days custodial orders against all the respondents. Your Honor, attached on the notice of motion of P3809 of 2025 is a supporting affidavit of number 63, 734, Corporal Hilary Kimayu. I'm sorry. Number 63, 734, Corporal Hilary Kimayu. Kimayu, KIMUYU. Your Honor, is attached at the DCI Operation Support Unit. Also, Your Honor, attached are inventories of recoveries made from the residence of Your Honor number. The first one, Your Honor, is the recovered inventory of items recovered from number 96146 PC Ileli Cyrus
PC
Ileli ILELI Cyrus Kisamwa is the second respondent. Samson Mureithi Mutogu. Your Honor, Mutogu is spelled as M-U-T-O-N-G-U. Your Honor, he is the third respondent. Your Honor, among the offenses being investigated, Your Honor, in paragraph 2 of the notice of motion, Your Honor, it's being in possession of ammunition contrary to section 4A contrary to section 4A 1A of the Firearms Act. Your Honor, the second offense is being in possession of a firearm without a certificate. Your Honor, contrary to section 4(1), 2A, 3A of the Firearms Act. Conspiracy to commit a felony contrary to section 393 of the Penal Code. Your Honor, being in possession of government stores contrary to section 324 of the Penal Code. Your Honor, the matters are reported at Capitol Police Station. Your Honor, be the OB numbers. Number 2 and OB number 56 of 26th September 2025. Your Honor, the first to the 5 respondents. Were arrested as a result of an ongoing investigation. Reported via the OB number 02/26/09/2025. At Capitol Hill Police Station. Your Honor, upon arrest and searches, recoveries were made which are captured, Your Honor, in the inventories. Dated 26 September 2025. The recoveries were made from the 2nd respondent and the 3rd respondent residences. The recoveries were made from the 2nd and 3rd respondents' residences. Your Honor, paragraph 4 of the grounds gives the background, rather the preliminary investigations have revealed. Your Honor, in paragraph 5, the first 5 respondents are serving security officers. Your Honor, we are serving security officers who are serving in the Kenya Prison Service and the National Police Service. Your Honor, there is an apprehension that if the court does not grant us these orders, Your Honor, they may contact and intimidate potential witnesses who are both civilians fellow officers. Interfere with yet to be recovered exhibits stored in official armories, also, Your Honor, they may frustrate ongoing efforts to trace accomplices who may be their juniors or associates. Your Honor, also in paragraph 6, in regards to the first respondent, Your Honor, he may be a flight risk. Since, Your Honor, he has direct links to the Lokichogio market, which is between the Kenya-Sudan border. And may abscond. Your Honor, the investigations, that is in paragraph 7, are still at a delicate stage. Your Honor, since ballistic reports are not yet ready for the firearms and magazines which were recovered, Your Honor, the mobile phones recovered from the respondents have not undergone forensic examination. Your Honor, additional suspects in Turukana, Nairobi are yet to be arrested. Also, Your Honor, there are there are documents which are yet to be recovered from the police and prison armories. In regards to issuance of ammunitions and magazines. Your Honor, further to the charges listed in paragraph 2 of the notice of motion, that is on the matters being investigated on, or rather the charges, then there's an apprehension of further analysis of the mobile phone. The ballistic reports, and the audit that may be done in the police and prison armories. Further charges may be brought against the respondents. Your Honor, in paragraph 9, Your Honor, the nature of the offences that directly touches on issues of national security. And Your Honor, it also touches on the volatile situation in the North Rift region. Therefore, Your Honor, the investigations cannot be concluded within the 24 hours. And Your Honor, we require a custodial period of 14 days. To safeguard the investigations. Your Honor, in regards to the sixth respondent, that is Isaac, you can teach in P3799 of 2025. Your Honor, we are also seeking 14 days custodial order against him. For the offense of possession of ammunition. Contrary to section 4A1A of the Firearms Act. Your Honor, paragraph on the grounds of the application, that is paragraph 1 to 4. Your Honor, Your Honor, it states how the sixth respondent was arrested. Your Honor, in paragraph 5, Your Honor, shows that some 1,007 rounds of 5.6 millimeters balls caliber ammunition were recovered from him. Your Honor, they were recovered in transit to Detain County. In paragraph 3 of the grounds that the sixth respondent Your Honor, he's an armorer, that is ARMOURER, armorer, attached at Turkana County Police Headquarters. Your Honor, we sought that Your Honor, as in from the previous respondent, that is 1 to 5.
So
I'm sorry.
You don't have the benefit of hearing what she said.
I was just confirming something.
Okay, you are done.
I'm done.
Okay. Then you can repeat.
Was going on to paragraph 8 of the miscellaneous application E3799 of 2025. Where Your Honor, the investigations against the 6 accused are not yet complete. Your Honor, and the same as for the previous respondents. Your Honor, we pray for 14 days due to the fact that this investigation touches on issues of national security. And Your Honor, if the 6th respondent is released, Your Honor, it may lead to, it may jeopardize recoveries and release and arrests of other accused persons. And also, it may also jeopardize the investigations being carried out currently. And also, Your Honor, may jeopardize the witnesses. Your Honor, his release of the 6th respondent, as in paragraph 10 of the grounds, may lead to interference with ongoing operations or investigations. Your Honor, therefore it's our prayer that you grant us 14 days to complete the ongoing operations, Your Honor, or lengthy investigations. And that's all.
Mr. Kusi.
Yes, Your Honor. Your Honor, I wish to respond to the application. Pardon, Your Honor?
Yes.
Did you say something before I proceeded?
No.
Very well. I wish to respond to the application by the prosecution on behalf of the first and the sixth respondents. Briefly, then my learned senior would rise to also say something about the same. So, you know, we oppose the application for 14 days. And you know, our position is based on the fact that
You can just remain seated. No problem. Just do the microphone. Yes.
thank you. Our position is grounded in the fact that the first and the sixth respondents, having been arrested on Friday, that is the 26th of September 2025, I've spent three days and a half in the custody of the arresting officers and the investigating officers. And you know, from the time of their arrest, statements of them have already been taken. Their communication gadgets are already also taken. So in our view, the part of investigation that requires their physical presence and in custody of the police has already been discharged. You know, I have also had the opportunity of going through the grounds of the said application as well as the supporting affidavit. You know, and in seeking 14 days to continue holding the respondents in custody, it has not been demonstrated and beyond reasonable doubt for that particular matter how the respondents are going to interfere with the remaining part of the investigations. Yeah, we note that they intend to engage ballistic experts, forensic experts, forensic analysis experts. But you know, the prosecution has failed to demonstrate how these respondents are in control or will be in control of the experts that will be conducting ballistic analysis, as well as those that will be doing forensic analysis. Because their phones have already been taken. Whatever exhibits that are alleged to have been recovered from them are already in the custody of the investigative officers. They are no longer going to be in charge of you know, they will no longer be in any control of the stores. And they also founded the application on the fact that further charges are intended to be brought besides the ones that I've already listed. And you know, you will wonder how the intention to bring further charges should justify the application for 14 days custodial orders. Yeah, you know, there is an allegation about the threat to public safety. It is our submission that that allegation is far-fetched. Nothing has been demonstrated before this court to prove that our respondents are a threat to public safety. If anything, you know, we submit that the Republic has enough law enforcement officers who are equal to task. they are equal to task and capable of safeguarding the safety of the Kenyan public. Regarding the allegations made against the first respondent, that he is a flight risk. Again, we believe that those allegations are just made out of a hidden malice against the first respondent. Who, from what is contained in the document supporting the application, is also a police officer and has affixed a board in Lodwar which has been his workstation. And where his family both the nuclear and extended live. His entire family lives in Lodwar. And Lodwar is still part of Kenya. The prosecution mentioned that the first respondent is linked to something called Lokichogio Market. Even if there was something called a Lokichogio Market in Lokichogio, the prosecution has not demonstrated how that justifies that the first respondent is a flight risk. And so that I also give my learned friends an opportunity none of the intended occasions by the investigating officers,
None of the
intended activities by the investigating officers will be negatively affected by the liberty of the respondent. So the apprehension by the prosecution, in our view, is speculative and unreasonable. It is our prayer that you dismiss or decline the application by the prosecution. And consider granting alternative conditions. That is all for me, Your Honor, and
Usually one person covers all the areas,
Sorry, Your Honor.
so that just a moment, counsel. I think we are going to give one of your colleagues.
Your Honor, I didn't have that instruction, but since my able colleagues are here, maybe I might have missed one or two things in the course of my submission, in which case they might be at liberty to address court.
Anyoka, you are for the first also,
No, that's sixth.
so you will come last.
The sixth.
You will come last now. So that we just already have to discuss.
Yes.
Just
Your
one
Honor.
request.
And I'll be brief because most of the parts have actually been dealt with. Yes. Your Honor, first of all, we have to agree that there's no legal requirement that suspects must be detained for investigations to continue. It's not enshrined in any law in this republic. The only exception accorded to the police is when they move court with compelling reasons. And those are basically valid grounds to detain during investigations. Maybe I'll give 3 examples. Risk of evidence tampering, flight risk,
So
probably ongoing identification of forensic investigation. Or probably taking DNA. Yes, from the look of things, Your Honor, we've been presented with a few proposed charges, which I believe you've recorded, which you don't need to record again. I could just give it roughly, or rather speedily. There's no way being in possession of ammunition contrary to the sections that have been recorded requires the presence of an accused in custody. There's also no way being in possession of a firearm without a certificate requires the presence of a suspect in custody. There are records they could check within their custody. Yes, and there's also no way a conspiracy to commit a felony requires the presence of a suspect in custody. All they need to do is to analyze the evidence they have. And also being in possession of government stores for somebody who's been relieved of his duties. I don't believe his presence is required unless they want a confession. I believe what the prosecution is short of telling us is they need a confession, but basically using, describing it in a very wordy way, which to me is unlawful. Jonah, in regards to the inventory of the second respondent, basically what I'm seeing there is personal items that were given to him by the police force. Save for one or two things Yes. Your Honor, basically what is itemized here are things like his jungle hat, his phone, travel bag, a police certificate of appointment, a police crown, Your Honor, to investigate these things, I don't think it requires the presence of a suspect in custody. They have all the records with them. And there's no way whatsoever a suspect can interfere with a police force doing its investigation. Your Honor, when the accused was arrested, he was taken to his house. All they needed was taken. And there's no indication from the prosecution that they intend to go back and get more items or more evidence from his residence. Your Honor, prosecution is known to be bringing charges while matters are ongoing in court. Whenever they pick up new evidence. It's not something new. Your Honor, just to conclude, we are of the view that the accused, and more so the second respondent, should not be put in custody anymore, because I believe they're done with what they needed. All the investigations that they intend to carry out are no longer outside the police, I would call it custodian. Anything to do with ballistics, confirmation whether ammunitions are within the records or not, are from whichever place they are from. Those are things police can do without the presence of the accused persons. So we do pray that the court deny the prosecution the prayers for keeping the suspects in custody for 14 days. I'm done.
Thank you so much, Your Honor. We post the application for custodial orders against the respondent. You post the application of custodial orders against respondents 3 and 5. Your Honor, respondent 3 was arrested on Friday, 27th of this month. It has been in custody for more than 72 hours. Your Honor, I had the privilege police station, and we were denied access to them, informed that they were still being processed. We brought to court today. Your Honor, for the application now and the order sought, we need to ask ourselves a number of questions. For ballistic analysis, they need my respondent to assist in any way, and the answer is no. The firearms are with the investigators, and the accused has no expertise, or they are not needed for that exercise. We need to ask ourselves the second question. Yeah, Honor, we need to ask ourselves, for digital and forensic, cyber forensic, the IO who has the phone and the SIM card in it, we still need the respondent or the accused for the experts to do their work? The answer is no. Your Honor, the next question is that the police believe that there is public safety in question. Your Honor, accused number 3 and 4 in a Republic of Kenya cannot be said. The police cannot handle the issue. And if so, we still have arms to deal with that. Your Honor, before anyone is arrested, there must be ground for them to be arrested, and they must have done their investigation before that. The question is, do you do the investigation after arresting an accused, or should have done your investigation before you come to this honorable court to bring an accused? And the answer is, you should have finished your work of investigation, arrest the person, then arraign him in court, but not the vice versa. Your Honor, it's alleged that they are going to interfere with witnesses. The next question would be, do we know those witnesses? Your Honor, the answer is that we don't know whether they are, those witnesses even one. Your Honor, there is an allegation that they hold positions. Your Honor, there is no demonstration that they hold those positions, and none of the positions have been given that is high-ranking. Your Honor, on the point of conspiracy, this is a driven own opinion. So we cannot say that we know there was any conspiracy. This is what the IO has come up. Your Honor, they say additional suspects are yet to be arrested. Your Honor, the accused are not in any way involved in arresting. So we cannot say that they are going to interfere with other people being arrested. Your Honor, accused number 3. Your Honor, we need to ask ourselves whether accused number 3 and number 4 lives in Rodwa. And the answer is no. Then we need to ask ourselves, is it that everyone living in Rodwa is a flight risk? And the answer is no. That would not be a good reason, enough reason to hold them for 14 days. Your Honor, the police have conducted the search in the house of the third accused, who lives inside the government property where we have the government stores. And they carried out what they wanted to carry as evidence. So I don't see anything that they need to do for the extra 14 days that they're asking for. And for that reason, I oppose their request. Thank you.
Mr. Bari, Mr. Zeta, and Mr. Mbui.
Yes, Lord.
Are you each going to speak or one is going to?
We'll split. I'll deal with the affidavit. Mr. Shadrach will deal with the application for bail. Mr. Mbeta will deal with the authorities. Yes.
Mr. Mbeta, the body language is
The body language is? No, my body language is actually that's why I was telling Mr. Mari, so that to avoid feeling a little bit sleepy is just stand up.
Yeah.
We are used to that.
okay.
Yes.
Yeah.
I left it open if you feel like sitting.
Yes. Most of them. Thank you very much.
Your Honor, we do appear for the fourth respondent, who the state wants to detain for 14 days. And the state has not mentioned anywhere the fourth respondent in the supporting affidavit. If indeed they wanted 14 days, they could have provided that in their supporting affidavit. Number two, in this application, they don't provide a nexus in paragraph 2 what they want the fourth respondent be detained for. They are provided in their notice of motion. In 2A, they are asking to investigate him, that he was in possession of an ammunition. They are annexures and or the inventory. There's none for the fourth respondent. So they never recovered any ammunition they want to investigate. to Your Honor. Thank you. They want to investigate him on B in possession of a firearm without a certificate. No inventory to that effect. D, Your Honor, it's in possession of government stores. Nothing was recovered, and there's no inventory to that effect. Lastly, Your Honor, they want to investigate him of a conspiracy to commit a felony. Nothing was recovered from him to support that he had an intention to commit a felony. And that is why the investigating officer has not sworn on oath in the supporting affidavit to link the fourth respondent to anything he's investigating. You know, the fourth respondent is a chief inspector of police. Designated as an armorer. And his job description is to repair guns. For Cliff to know, simple, he's a mechanic of guns. Spoiled guns which can't fire are taken to him to repair. he does not at any one time receive a gun that is alive. He receives spoiled guns from the whole country. You know where he is detained now? At Capitol Hill Police Station. The OCS will send 2 spoiled guns to him. He will prepare those guns and return them back to the service. And I wanted to distinguish an armorer and the one called an armory, in charge of an armory. An officer called in charge of an armory. His possession of proper functioning guns and proper functioning live ammunition at his disposal. Logically, that's the one who can sell guns. You know, the 4th respondent can only be charged of selling spare parts. Paragraph 2 does not produce that out. Your Honor, on the 25th day of September 2025, this date is critical. The 4th respondent was issued with a notice to compel attendance. By one John Kiragu for the OC DCI Operation Support Unit. There was no report about this investigation. The report is better. OB number 2. The OB that resulted on his arrest is OB number 2 and 52 of 26th September 2025. A day after officer had been issued with his summons. As a law-abiding police officer, he reported on the 26th September 2025 before the investigator. The investigator extended the compulsion to attend to 29th of September 2025 at 08 hours. And the officer signed. The fourth respondent walked himself and was locked up. A clear indication that is a law-abiding citizen and an officer ready to comply. Based on those facts, Your Honor, I have instructions to make an application for the fourth respondent to be released on cash bail and in the alternative bond. Your Honor, the basis I've laid clearly demonstrates a person that will be ready to comply with the conditions of this court. Your Honor, all the inventories presented before you there is none specific to him. And the reason is now coming. You know, when a search was done in his house, Kenya shillings 550,000 shillings. Kenya shillings 550,000 shillings was taken from his home This being the school fees, Shadrach will bring out the amount was for a child who is supposed to go to school, to university. You know, we have laid enough basis to consider the application, and Shadrach will lay the law and the facts to support that he needs to be released on cash bail and bond terms. Thank you, Your Honor.
Does it require sunglass receivers?
The light is a little bit bright. Maybe it's the flash. The camera.
Thank you, Your Honor. With your permission.
Mr. Mali, I like the speed.
Eh?
Bright without pressure.
Yes, Your Honor. Thank you. I'll borrow a leaf from him. Your Honor, if it pleases you, for the record, my name is Wamboi, Shadrach Wamboi. I appear alongside my learned sister, my learned seniors for the fourth respondent. Your Honor, I will choose to be brief. And at the outset, Your Honor, permit me to mention that the application that lies before court is a serious application with very serious ramifications. Serious ramifications for one, Your Honor, for the life of the fourth respondent hangs on a balance. His employment, Your Honor, is at stake, and his reputation and that of his family is equally in jeopardy. For the foregoing, Your Honor, this honorable court is invited to exercise great caution as it endeavors, Your Honor, to come up with a decision on whether or not to permit the pre-trial detention of the fourth respondent. Your Honor, as counsel that has practiced such applications before, I am glad that the court has not been invited to walk down a path that has not been walked by previous courts. Stated differently, Your Honor, this application is not novel. And as such, Your Honor, you are invited to
apply principles that have been set previously. So that, Your Honor, we accord the fourth respondent great care we accord him great care, Your Honor, protection, and the prevention against any violation of his rights and fundamental freedoms. Your Honor, in the authority I have shared with the court, that of Oscar Sudi Kipchumba versus the Republic, criminal case number 208 of 2020. It's one of the authorities I've shared, but that is one that I will want to lay emphasis on. Your Honor, this court is only permitted to allow such an application Your Honor, it is only permitted to allow such an application when it has been demonstrated by the state Your Honor, I make reference to the counsel for the prosecution that the detention of the fourth respondent is less restrictive measure. In other words, it must be the last resort to seek to detain someone before he can properly be informed of the charges that he faces, and in any event, Your Honor, before he can be convicted of any charge. Your Honor, my senior, Mr. Dunstan Omari, has made reference to a notice to compel attendance dated the 25th day of September 2025. And Your Honor, I will pray that you also take a glimpse of it. That document, Your Honor, is proof that our client, knowing too well that he was required to assist in the investigations, attended those summons on the 26th day of September. Your Honor, behind that notice is the writing of the investigating officer in a blue pen. Extending those summons to a later date, which is today. Granted, Your Honor, from the 25th day of September 2025 to today, our client had enough opportunity, if he so desired, to interfere with witnesses, to run away from the jurisdiction of this country, to hide exhibit, but he chose not to do that. Begs the question, Your Honor, why at this juncture we will be applying to detain him for 14 days. No reference to him has been made in the supporting affidavit. Appears that he was just squeezed in as a respondent in these proceedings. Your Honor, to be fair to the investigating officer, Mr. Hilary Kimuyu, he has not found any cause to justify why the fourth respondent should be detained for 14 days. Your Honor, it's clear that the application, as far as the fourth respondent is concerned, has not been made in good faith, and it is meant to achieve another ulterior motive or purpose. As a consequence, Your Honor, and in the name of paragraph 24 of the Oscar Sudi case, that application should fail. And we urge the court, Your Honor, to disallow the invitation to detain our client for 14 days. In closing, Your Honor, I must equally urge that even, Your Honor, while you might look at my client on the face value to find that he's fit and proper, Your Honor, my client is a sick man. He has been unwell since the year 2021 after he suffered COVID-19. He has had chest problems, and under a doctor's supervision, for at least every fortnight, he must visit the hospital. Over and above that, Your Honor, he suffers from serious and acute ulcers. He even walks with his medication. He can show you. He has his medication with him. For the purpose of the court record, Your Honor, he has even produced a number of tablets that he must use quite often. For that reason, Your Honor, it will be inhumane to detain an innocent and sick suspect, Your Honor. I urge that you find in favor of our application for bail, permit him to join the rest of his family. I rest, Your Honor.
You know, nowadays I've learned to watch the hand. Nowadays I speak slowly. I've learned to regulate my speed.
You should pay me, I taught you
Yes.
to talk slowly.
Nowadays I speak. And let me start by asking whether the police and the state have come here with clean hands. More so the police. They want you to detain the respondents for 14 days. Knowing very well that these respondents have fundamental rights. But the first thing they do is when we go to the station, they chase away the lawyers, denying the accused person his right to see his lawyer, and the lawyers the right to talk to the respondent. Yet they want to come to this court.
Slowly, man.
Yet they want to come to court and ask for 14 days. The question then is simple. Can you trust the respondents in their hands? For 14 days. As we say that you cannot in that answer, let me now indicate why this application must fail, what the state needed to prove. They needed to prove that the fourth respondent does not have a fixed abode. What contradicts that is they did a search in his house, so he has a fixed abode. They needed to prove to this court that not only to say that he will interfere with witnesses, that he actually has interfered with the witnesses. In the case of which the authority have provided, of Dwight Sagarai versus Republic, High Court case number 61 of 2012. In page number 4. Third paragraph. What does the court say? And I'll read that part only. For the prosecution to succeed in persuading the court on this criteria, however, it must place material before the court which demonstrates actual or perceived interference. Actual or perceived interference.
Do I have?
Yes, give it. It must show the court, for example, yes.
Let the court have it first.
You know, we have supplied all copies.
Dwight Sagarai, number 61 of 20.
You know, we have an extra copy. We can still share.
Yes. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and the witnesses. Just to remind the court, we don't know who the witnesses are. for the prosecution to prove to the court that the fourth respondent is a flight risk. They must place material before the court. The case of Richard Alden versus Republic. High Court case number 48 of 2016. Before Justice Lassit, as she then was. What did the court say? For the prosecution to even say a person is a flight risk, must place material that the person has attempted to flee, has made arrangements to travel, or has bought something like a ticket. Material that can be verified. In the absence of that material, the court is left to speculate or imagine. And we are here for facts, not imagination. And Your Honor, if in these two instances of flight risk and interfering with witnesses have failed as they have right now, they remain with one thing. Issues of national security. Your Honor, in the authority of Dwight Sagarai, it is clear, the court have said, in matters of national security, yes, or national interest, or public interest, it becomes the burden of the state to place material before the court to show how the respondent has interfered with matters of national security, when, where, and how. So that again, the court does not enter into the realm of speculation. Then it is now why I must then refer back to the issue of the compelling of attendance that you have been given. The police grant the fourth respondent an attendance document. He does not fail to attend. Otherwise, they would have said it. The antecedents that we usually talk about, isn't this a good case, Your? But today they come and tell you, denying bail for the next 14 days. And this is why Article 19, Your Honor, is very good for the respondent. It is very clear in Article 19. The fundamental rights provided for belong to an individual, not the state. And therefore, they cannot blow hot and cold on this fundamental right. And Your Honor, the reason why these fundamental rights exist is to prevent the fourth respondent suffering what he's going to suffer and to save him from such excesses that the state is demonstrating. You know, now the fourth respondent has become a ward of this court. So how do we rope you in? You know, Article 20 and 21 are very clear that these fundamental rights must be observed by the state, the court, the police, and any other organs. And therefore the court must start by wanting to ensure that the respondent enjoys these fundamental rights. Start by wanting to ensure. So we have noticed that the state does not want this to happen. Yes. Yes. So we have noticed that the state does not want to ensure that we get these fundamental rights. We come then under Article 22 and ask the court to ensure that the fundamental rights of the respondent are fulfilled and enjoyed. The state then comes and tells you, these are persons who are police officers and in authority. Do not give them bond. How does that work with Article 25, where you're not supposed to discriminate against any person? How does that work? That should also open Article 27. Same thing. As I sit down, Your Honor. I will also ask you to look at Article 28. Whereby the dignity of an individual is an integral part of him. It must be preserved. The fourth respondent has not been charged yet. And eventually may not be charged. And that is what we pray, because there is nothing on him. At least, Your Honor, maintain his dignity, granting bond. Give conditions that you want, Your Honor, to ensure that he appears on whichever day the court may wish. On the number of times the court may wish. On the type of security the court may wish. So that with dignity, as the investigations go on, he can come to court. That is all I wish to state.
Your Honor, being the last speaker, I have had the privilege of keenly, carefully and patiently of reading and perusing the Bill of Rights. I've also looked at the other provisions of the Constitution. I've not seen anywhere where there is detention before commencing investigations. Is on that account that the sixth respondent opposes the application for request for custodial orders, which application, Your Honor, though couched in general and routine manner, it however seeks some very drastic and draconian orders which have the effect of violating certain fundamental articles or provisions of the Constitution. Your Honor, the orders being sought by the prosecution offends Articles 24, Article 25, Article 49, and 50 of the Constitution. Your Honor, the limitation of 14 days that is sought by the applicants is not reasonable and justifiable. The same violates Article 24 of the Constitution. Your Honor, further, it's prejudicial to the right to fair trial that is guaranteed courtesy of Article 25 of the Constitution. Your Honor, Article 49, sub-article 1, sub-article H. An arrested person is entitled to be admitted not only to reasonable, but lenient bail bond conditions. Unless, Your Honor, there are compelling reasons. Your Honor, in Republic versus Danson Mugunya, Republic versus Danson Mugunya, and another, into brackets 2010, brackets closed, EKLR, the learned judge had this to say: compelling reasons must be specific and supported by evidence. Compelling reasons must be specific and supported by compelling reasons. And supported by evidence. John, and another authority, Nganga versus Republic, into brackets 1985, brackets closed, KLR 451. Seriousness, the judge had this to say: seriousness of an offense alone is not sufficient to deny bail. Your Honor, right to liberty, courtesy of Article 19, that's on rights and fundamental freedoms. Is emphatic that the right to liberty is paramount and that the detention should only be enforced only on the rarest of cases. Your Honor, I have had ample time to go through this application and the supporting affidavit. I have not seen any compelling reasons that warrant the taking away or interference with the liberty of the sixth respondent. Your Honor, paragraph 8 of the supporting affidavit refers to ammunitions which were counted and found to be 1,007 rounds. As we are before you, this particular affidavit is not supported by the purported inventory. The same is thereby speculative. Your Honor, paragraph 10 of the said affidavit, rather paragraph 11, alludes to recovery.
It's not at this point. If you finish today, I'm not going to so it will make no difference.
In the next about 5 to 6 minutes, I'll be through with my very brief submissions. Your Honor, it refers to recovery of crucial documents involving government agencies. It has not been demonstrated that the sixth respondent.
Mr. Nyapa, you got me right.
Yes, Your Honor.
You got what I said.
I thought you gave me around 10 minutes to
No,
conclude.
we're stopping at this point. So that we continue tomorrow, finish tomorrow, and you have a ruling tomorrow. Even if you finish today, you come
Yep.
for a ruling tomorrow.
Your Honor, maybe you can, because I have some very crucial court of appeal matter in the morning. Can you stretch maybe for 5 minutes? I'll go through my submission very fast and conclude.
Yes.
Around 7 minutes. I'll surely conclude. Yes, Your Honor. The issue of recording statements from various witnesses, this is speculative. We have not been guided by the nature of these witnesses. No evidence has been tendered that the sixth respondent has attempted to contact or interfere with these witnesses. Your Honor, further subjection of recovered ammunition for ballistic examination. The sixth respondent has no role to play. Those are government agencies. Unless the prosecution alluding to the fact that they do not trust their agencies to carry this without interference or being compromised. Your Honor, the prosecution has requested for 14 days. The sixth respondent was arrested on 25th of September 2025. Those are 5 days because today is already over. Those are 5 days. Before they seek for 14 days, they must first of all come with clean hands. They must demonstrate to the court what they have done for those 5 days when the sixth respondent was in custody. Your Honor, finally, presumption of innocence is an important right available to a suspect or accused person. The continued detention amounts to punishment before conviction, which is contrary to Article 50, Sub-Article 2, sub-article G. Your Honor, the sum total of those submissions is that the prosecution or the applicants have not put any material. They have not been able to demonstrate. They have not been able to persuade the court into interfering with the liberty of the sixth respondent. And we therefore urge the court to proceed to release the sixth respondent on not just reasonable but lenient bond terms. That is all. Your Honor, thank you for accommodating me. I believe I've had a saving of my 7 minutes. I've been able to exhaust on before 5 minutes.
Yes, you've taken time. Thank you.
And we'll do some call.
Just, Your Honor, very short. Very short, Your Honor. I'll be very brief. Your Honor,
How many minutes?
I'm not even taking more than 5 minutes. Your Honor, the application has been brought under section 36A of the Criminal Procedure Code. Where, Your Honor, which requires the police to demonstrate reasonable grounds for continued detention. Which the court will balance the suspect's rights public interest and the integrity of the justice system. Your Honor, in a reported case, that is Republic versus Aroko, (2025), KEHC 6422 KLR. That is a citation.
You have it?
Yeah, no, Your Honor, I've just found it as my colleagues were making their submissions. Your Honor, as you retire, if you may take a look at paragraph 6, paragraph 7, also paragraph 9.
You found it through AI.
No, Your Honor, not through AI. Your Honor, just a simple Google search. Even though my colleagues are laughing, but Your Honor, Your Honor, it's relevant to this matter. Your Honor, as you retire, if you may consider paragraph 6, 7, 8. Your Honor, Honor, I'll not belabor and read those paragraphs. Your Honor, the investigating officer has demonstrated compelling reasons on why the 6 respondents should remain in custody. You are not considering that the offences touch on issues of national security as shown in paragraph 9 of the grounds in the notice of motion dated 29 September 2025. Your Honor, I urge the court to grant us the 14 days custodial order. That's all.
So tomorrow what time are you available?
Yes, Your Honor.
Tomorrow what time?
We are available. We have at 10 will be before Justice Mugambe, but then I don't know. You do often counsels are engaged.
After
Closing 2:30 p.m.
3:30 p.m.
Yes.
Tomorrow we have the DCI.
Yes, Your Honor. And I have witnesses I can confirm. Yes.
Means the last you are not of balance. Tomorrow at 2:15.
That's convenient.
Okay. In the meantime, you want me to contact you again? Okay. So the rest of us will be held at Capital Gate Police Station until 10.
You know, before you turn off,
Yes.
we'll be seeking that you issue an order that we be allowed to access our clients at the capital police station. It's a problem with the OCS with them. Yes. We've never complained of that, but it's strange that we were today denied access.
Their counsel will advise them accordingly. Madam Radis. We need to add announcements to the law council to access.
It's okay, I'll speak to you.
As long as we don't do what happened in Mugai.
I was in that matter, but it was not me. You can get the matter. Thank you. Sorry.
I want to sign before I rise.
Okay, no problem.
No problem.